law, there is also international rule of law. And then there is a critical interrelationship between international arbitration and rule of law. And this you will have heard of and about, I'm sure, all through the morning when I was absent. But here are a number of key crossover points, which will be important when we get to the question of diet. The process of international arbitration is an operative element in domestic and international rule of law because it's part of the machinery. It is a core component of how disputes are resolved, which is a complement to other forms of dispute resolution and therefore part of access to justice. A significant number of cases are now in arbitration, so that is part of the international machinery of rule of law. Secondly, in particular, investor-state arbitration is a mechanism that was originally designed to depoliticize disputes. So the objective of that was to take disputes away from the vagaries and uncertainties of policy and politics and interstate dynamics and take it into an objective sphere of legal rules and criteria. That was noted by Aaron Brockers at the beginning of the ICSID process, noted that the ICSID Convention identified a means of settling directly on the legal plane investment disputes between states and foreign investors, insulating them from politics. And that has been famously said by Poon, actually, amongst others, that contributes to peace because it minimizes sovereign caprice. It takes away disputes from all the negative aspects of politics and international stresses and strains, and ultimately warfare. And so what we're looking at is to shift disputes to an objective criteria-based, rule-based, not power-based system. That's all the interrelationship between arbitration and rule of law. And then further, you have treaty standards now that are corollaries to domestic constitutional law guarantees. So they themselves reflect rule of law principles. And lastly, investor-state arbitration in particular is designed to improve domestic rule of law and therefore, in turn, international rule of law. What it's doing is applying externally standards into host countries in order to improve the situation locally. Now, in the last 20 years, we have had a growing diet of cases. It's been an exponential rise. And now the area is truly well fed in terms of cases, jurisprudence, in terms of professionals and specialists, that's counsel and arbitrators, in terms of established rules and processes. But the core point that we now face is that the diet has changed. And we know that if you make a significant change to your diet, that may cause digestive complications. It may put stresses and strains on your system. It may destabilize you. It may cause a range of gastric consequences and bathroom experiences that we'll not dwell on here. The key point is that the diet in international arbitration, and in particular investor-state, has significantly shifted. And I'm not talking about lunchtime at the IDRC. I am talking about the cases, the disputes that are coming through our arbitral system. They are now very different from where we started. We started in good old-fashioned investment disputes, which were readily understandable, building a project somewhere, and then some form of limited intervention by a state, which had to be resolved by a treaty tribunal. And that was rather close to contractual arbitration in terms of the subject matter and in terms of the types of intervention and interference. But now that has changed because our field has become a barometer of world events. Because we have stretched the notion of investment, we've stretched the notion of investor, and we've stretched the notion of what constitutes harmful conduct to both of those. We are now in a diet which is well beyond what was the area of diplomatic protection, well beyond that. Now we are dealing with climate change. Now we're dealing with war. We are dealing with health policy and pandemics. We're dealing with economic policy. We're dealing with reactions to states of emergency and dislocation. So what is the impact of that new diet on our system? There are a number of key impacts which we need to focus on. Firstly, there are now stresses on the procedural system itself. There is increasing criticism, we all know, of investor-state arbitration in particular, and there's a thin line between investor-state and many forms of international arbitration, true and proper, which also involves state issues. There are standard criticisms, of course, about cost, efficiency, consistency, impartiality, transparency, cases. But the diet change actually raises much more of a fundamental issue, which is the very suitability of this process in the first place. The actual process is not the obvious one for these kinds of disputes. The diet has changed, but we're still using the old system, thinking we won't need a chemist. And that is fundamentally where the tension comes from. Our system of a basic Anglo-US adversarial model that was developed in the context of old-fashioned style disputes doesn't meet climate change. It doesn't meet war. It doesn't meet economic policy. Any area that involves nuanced, delicate questions of policy, how can you resolve that by an adversarial system that involves polarized argument? As a tribunal, you are sitting with two camps in front of you. The arguments are extreme on both sides. They get more and more extreme and more entrenched as the case develops. Policy is not made in that way. Climate change isn't resolved in that way. Policy is in the middle ground, where things are grey and not black and white. And that middle ground isn't addressed in an adversarial process. And then further, the adversarial process excludes the interests that may be affected by the actual decision. Climate change or war, economic policy, health policy may involve a whole range of stakeholders. But where are they? The adversarial system has no interest in them. And the commercial arbitral mindset has no interest in them because it's designed to resolve the immediate dispute with which the tribunal is faced and nothing further. And therefore, there's a major mismatch. And that leads to another dietary problem. And that is the idea of depoliticization is now defunct. We are not depoliticizing disputes, not these kinds of disputes. Depoliticization, even if I could pronounce it, is not real in many cases because the nature of the dispute itself is political. So how can the resolution be non-political? It's not going through some sort of filter where all the debate that takes place nationally somehow evaporates. The debate is there, but we're pretending that it's not there because we're applying legal principles. But the legal principles that we're applying are broad with no precedent. We're told fair and equitable treatment, but we don't know quite what that means. And we can let it mean what we think it means because we're not bound by any particular principles. And so ultimately, tribunals are, whether they like it or not, placed into a maelstrom of politics. But it gets worse. If one actually stands back and applies the pre-lunch principle that the proof is in the pudding, actually the proof when you eat the pudding is rather uncomfortable. Because if you look, just stand back and look at what the effect of international arbitration is now. Arbitration comes along to a dispute, it happens, and then it's over. What's left? If you stand back and look beyond the meal at the aftermath, look at the arbitral aftermath now. Just stand back and look. What have we done? We have politicized major disputes. Tetian and Pakistan, an 11 billion claim award of damages against the state of Pakistan, which was equivalent to the entirety of Pakistan's IMF lending in 2019 for a dispute that never happened. A project never happened. The project never went beyond the planning stage. We as lawyers can perfectly understand it and we can justify it. If you're sitting in a rickshaw in Lahore, as I was last week, seriously, everybody's talking about it. Everybody, including a rickshaw driver. Rickshaw driver can't understand that. The case has come and gone. It's settled now. The lawyers have moved on. We're now doing other cases. But the aftermath hasn't finished. That aftermath has led to Pakistan not moving just away from all of its BITs, but now distrusting public international law. Not sensible, but that's the actual practical impact. That's the arbitral aftermath. It's not just Tetian and Pakistan. One can think about any number of cases. Von Pezzold in Zimbabwe. A tribunal apparently applying objective criteria and legal rules only to the most emotive, difficult social issue of land distribution in Zimbabwe, forestry in South Africa, black economic empowerment, white industries in India. Look at the aftermath. Vattenfall in Germany, and so it goes on. And so the result is that all the rule of law interconnections that we spoke about are now actually not operative. If we want to impose standards externally on a country, are we doing that in our process? Actually, we're not. What we're doing is we're forcing countries to walk away from the system. So we don't see an improvement in standards in Pakistan. We see Pakistan not wanting anything to do with this system, not just Pakistan, but many other countries. So you get no improvement in the domestic rule of law, but also you start to get a breakdown in international rule of law, because this is a major component, as we've said, of the international machinery, and the component is not working properly. And therefore, there are deficits now in the rule of law, but worse, there are inflammations resulting from the new diet. You'd never think that you have a lecture on gastric inflammation. What are the takeaways, or in the US, we'd say the takeouts from this? What remedies are needed to the changed diet? We can't change the diet itself now. The diet has changed. It's changed because we now have established concepts that we can't shift about the scope of investment, the scope of investor, the meaning of the standards. And that, I think, is something which will never be recovered now. And so it's the system within which these cases are coming that needs a look. But it's not just a look. It's a fundamental reconsideration. Because the tweaking that is being thought about now to improve it doesn't actually go anywhere near the fundamental reassessment in light of what is a fundamentally different diet of cases. And in particular, we may now be looking, and more commentators are saying so, that instead of depoliticization, we actually need repoliticization. We actually need to start to think of bringing disputes away from this so-called pretend objective legal plane into a political plane that allows all actors and stakeholders to have their say, that actually allows the people who are affected, the policy makers and the policy subjects, to be part of the process. And there's nothing at all in a US Anglo adversarial arbitration model that allows for that. And so the model actually itself may be utterly and completely different. Of course, there'll be a place for KCs. But short of that, it may bear little resemblance to what we are actually now looking at. This is a very, very brief taster to a full analysis on depoliticization that will be given at the Chartered Institute Alexander Lecture in November. But it would be wrong, completely inappropriate, and frankly tasteless for me now to be promoting the Alexander Lecture starting at 6 p.m. on the 8th of November. With virtual and in-person attendance available. So I'm not going to do that. I'm simply going to wish you all good digestion and bon appetit. Thank you.